Good afternoon. I think the buzzer that you have is meaningless because I follow that after the buzzer, the session goes on and on. I will break that rule and I'll make sure that we stop on time. So please don't hesitate to buzz us. It's a privilege and honor to be able to moderate this panel. I don't know when the organizers decided on this session what they actually had in their minds. Most of you know I'm a tax lawyer, I'm not a deal lawyer. But now I have 3 lawyers who are deal lawyers. And the topic is interesting deal making across sectors, lessons from 2025. I had one of my research associates give me some information. I do work on deals, I issue opinions which are tax related, but I don't do the nuts and bolts of the deal, which these 3 lawyers do. So I just thought we will have an engaging conversation. Regrettably, we didn't have time to prepare. So, one of the questions I had in my mind is I didn't want to, catch anyone unaware with an awkward question. So I randomly sent them a few questions and I said, let's have a conversation. So whoever wants to answer the question first, feel free to do that. I don't need to introduce the panel and take everyone's time, but as I was going through some research material on the theme of this panel, I came across that there are some mega deals, there are mid-sized deals like it happens in India, and our panelists are fairly experienced and seasoned lawyers in both. I tried to look at which are the 3 important deals of 2025, though one deal was announced today morning only. So I'm not including that because we are still processing that news. So the 3 big deals were the Emirates NDB's $3 billion acquisition of RBL Bank. This is important because it's a major deal in banking and financial services. We don't see very many deals in banking and financial services. Then we have the International Housing Companies deal. This is acquisition of Samman Capital, an NBFC. Again, in NBFC sector, we see deals, but we don't see deals of this size. And third is the Tata Motors $4.45 billion acquisition of Iveco, which is the Italian company. Bold move by an Indian multinational, but not surprising given the size of Tata Motors. So in the automobile sector and in some of the other sectors, over 100 deals happened in 2025. There was a little bit of slowness in the deal insofar as US is concerned for the impeding trade agreement. Many regulatory changes took place during the year. Whether these regulatory changes brought in more deals or they are likely to pave way in 2026, we will also have some futuristic outlook. Let's come back to the panelists and debate on some of the important issues in 2025 from a deal standpoint. Let's first look at the regulatory issues. I wanted to come to press note 3 and whoever wants to go first. There is a calibrated move to take away or reduce the rigors of press note 3. It is unclear whether they want to reduce the rigor to attract more capital from China in categories such as manufacturing of electronic products. But certainly there is a move to attract money by way of strategic investment because the 49% cap is coming in. I just thought we'll take a quick view on this important development. What does it mean even from a futuristic perspective? Because last I could gather is that from the media that suitable papers are being made out and including the Prime Minister's office is involved. And I know talking to many, many deal lawyers, including you, that press note 3 was coming as a very important roadblock. What do you see this as a future? Do you see this likely happening?
First of all, thank you very much, BW World, for having me over as part of this discussion. And thank you, sir, for a great question. It is true that Press Note 3 continues to be a bit of a challenge for investors investing into the country. As most of you are aware, that Presno 3 was brought in the context of COVID and the context of military conflict at the border between India and China. To prevent opportunistic takeovers from China, this restriction was put in. Over a period of time, what we've seen is the fact that a lot of private equity and venture capital funds have also been affected by this particular rule, because the government of India believes that even LPs from China, which includes Hong Kong, will get picked up by this restriction. That has meant that true-blooded private equity investors and venture capital investors from the US and Europe, even if they have one LP from China or Hong Kong, is getting picked up in this Presno 3 restriction, and getting investments from them is becoming a challenge. You're also right, sir, that the government of India, if one has to look at the last 3 years or 5-year track record from 2020, since this press note came out, the number of approvals are far and few. And the group of ministers and the empowered group of secretaries, which is headed by the Home Secretary, that looks at all these proposals from land border countries, and that primarily means China, have taken forever. None of those approvals come in time. They're usually taking more than 12 to 14 months. And there's almost an unsaid rule that in certain sensitive sectors, we also saw pharma, for instance, where the government did not allow the Chinese investors to put in money. What that has actually done is that it's forced a bunch of investors and global funds to now come up with mirror fund structures, where they actually have two fund structures, one with the Chinese LP and the one without the Chinese LP when they're looking at investing into India. The second consequence has been that, literally in equity money from China has completely come to a halt. What we, however, saw was an interesting trend in the backdrop of what we saw with MG Motors, where the government said that an MG Motors being a wholly owned subsidiary of a Chinese company, government of India realized that in order to fund that company, the Chinese investor needed to fund it. And the government, I think, in a soft way, almost nudged MG Motors to say that, look, we will allow you to raise capital, provided you bring down Chinese ownership to less than 50%. And, they finally approved that investment, with a domestic partner, JSW Group, a renowned group, took 51% of MG Motors India. That paved the way, sir, for some more deals to be explored in the strategic sector, where the government was now willing to accommodate and allow exception on a case-to-case basis for technology intensive, so auto parts, auto manufacturing, renewable energy, semiconductor. These were themes where the government was willing to now look at Chinese investment non-controlled, so less than 50%. But then Operation Sindoor happened, and the role of China there sort of again assumed relevance. But then Mr. Trump happened when it comes in terms of tariff and the geopolitical climate. So India relationship with China is blowing hot and cold. We've now suddenly seen easing up of visa and travel restrictions. So one expects that, and the noise that we're hearing from the government is that, look, if you build a strong case that if you are only going to talk of capital from China, we will not consider it. But if you build a strong case that a particular Chinese investor is bringing in a kind of technology that is very critical for Indian economy, on a case-to-case basis, non-controlled deals, we might still consider.
Vaibhav, your comment on hot and cold concerns me, because from a certainty standpoint, it conveys that, and you mentioned Operation Sindoor as the driver for India to review the terms of Press Note 3. Something else could have happened in the future from a geopolitical standpoint. I don't know, as transaction lawyers, what would be your advice? So imagine a client, seeking your counsel on getting private equity from China. Would you consider that as safe? Maybe perhaps today, yes, but what happens to risk factors that you will have to weigh in for the growth of that investment?
Yeah, so what happens is, as a transactional lawyer, uncertainty of regulatory regime becomes one of the biggest challenge for bringing in capital. Now, if you are having, as Vaibhav mentioned, hot and cold situation, There is very difficult situation because you will not be able to have investment in mega infrastructure projects, mega projects which requires a lot of equity investment, because for the simple reason that today the relationship is good, tomorrow it may not be, and that would be an hindrance. Therefore, if you see in the last few years, most of the mega transactions have bypassed all of the Chinese, all of the Hong Kong related investment. In fact, the largest investments that were happening were through the private equity route from the from Hong Kong. But that has all stopped because of the uncertainty. And the biggest thing that the private equity investors require when they come to India is, one is a tax certainty, the other is the regulatory certainty. None of which is possible if you have Press Note 3, and that is the reason that we have almost diminished all kind of investments from these territories. Approval rate is very low, and it's very painfully, tediously long.
It's interesting you mentioned tax certainty. Manendra, let me come to you. I specifically wanted you to share your experiences on deals where tax issues are involved. General anti-avoidance. I don't know if you know the news, just about an hour and a half back, the Bombay High Court, which is hearing the application of general anti-avoidance on the Hinduja deal, has partly heard the matter, and it's going to hear in January as well. In my professional experience as well, we see this emerging as an important roadblock. Do you see any changes in the future? Bear in mind, statistically, not even a single GAR case on merit has been decided. There is one matter which is lying in the Supreme Court, and there are all matters which are sub judice before the High Court. Either the stay has been granted, but no matter has been decided. So we don't even have one successful case that the tax administration has built on application of GAR, which becomes so important in a transaction. Manendra, your experiences?
Thank you, Mukesh, for that question. First of all, I am not a tax lawyer, so my views are going to be sort of a reserved views. But having said that, from a regulatory perspective, I think GAR plays a very important role. And specifically from a taxation perspective, because GAR gives tremendous power to the regulator to sort of see through the corporate structures and figure out what is actually resulting in the tax avoidance, and can actually question any kind of tax saving structure that you are coming up with. So from that perspective, I'm in agreement with the point that, look, as far as GAR provisions are concerned, there has to be some regulatory clarity on this. And of course, there is that Bombay High Court matter happening on the Vedanta matter, Hinduja matter. But having said that, I think there needs to be a lot more clarity that can come in terms of the GAR provisions. We have budget just around the corner, and maybe an industry consultation is something that should be done on this point, where the specific instances which are holding back from the deals perspective not happening, those provisions should be taken into consideration. For example, we see from structuring point of view, specifically say on the indemnity points, we see a lot of contentious issues that come up specifically on the tax indemnity, right? Those are the things I think the clarity is definitely needed. Of late, for example, in tax indemnities, we have seen insurances happening, right? Those are the things which are picking up because of these uncertainties growing over a period of time. So having said that, I think in a nutshell, there is that regulatory clarity that is required in terms from a deal structuring point of view, and specifically from a GAR perspective.
Okay, so let's now shift gears, little bit futuristic outlook. Vaibhav, Budget 2025 for the first time made an announcement on M&A transactions being funded by banks. We are staring at 2026 budget. It's still not been made applicable, as I'm told. But the RBI has been working in consultation with the IBA to look into this, which is also considered as a credible option to, ECB, which had its own set of restrictions on whether it can fund or not. Have you seen any movement in the M&A market, or do you see anything in the future that's coming in? To me, at least as a bystander, I feel that there is a very cautious approach. For example, you cannot fund share acquisitions, understandable. You cannot get into commodities, understandable. But you cannot now get into real estate as well. So that seemed a little bit more restricted to me. I don't know what your overall observations are, whether this is a calibrated move which is going to open over a period of time, or this is something that doesn't excite really deal lawyers like you.
No, sir. I think firstly, some of the themes that you're picking up are tremendously relevant and brilliant at that in terms of the impactful issues that they bring for M&A. Hand on heart, everybody got supremely excited when this particular proposal came through from the RBI. All my friends in the banking practice got really excited, and so did I. Just from a purely legal perspective, if M&A has to be accelerated in the country, and ultimately, we've got to do everything to facilitate growth. Inorganic way of growth will be the way to grow for most corporates. And we are now getting to a scale where M&A activity will be fueling the growth of the economy. In that backdrop, the reality was that today, sir, most companies were looking at non-banking financial companies to fund these acquisitions, because of two issues. And the Indian law on leverage buyout is so restrictive. For the benefit of the audience here, we still have a provision on the Companies Act which says that a company cannot finance purchase of its own shares. Clubbed with the fact that the RBI has very strict guidelines that banks could not fund promoters' contribution of equity. These two things, along with the external commercial borrowing guidelines, which say that ECB cannot be used for financing M&A activity. All three meant that debt as a capital source for Indian M&A was really, really restricted. Virtually did not exist. People had to resort to NBFC financing, which of course is far more expensive. And to my mind, opening this area will be very, very useful. It will allow banks to improve their balance sheet, will allow banks to do creative support for M&A activity in India. And Indian corporates will not have to look overseas to raise bonds outside to fund these acquisitions, which was the only norm that was taking place. And I think in this backdrop, I do want to tell you something, sir, that some of us who work very extensively with the RBI on exchange control, they reached out to us in a jiffy saying that, look, we are planning to rationalize the ECB guidelines to allow ECB to fund M&A activity. Can you tell us, how we can ensure that there's no abuse? And some of us have been working with the RBI, but this is all happening in the backdrop of a real economic challenge, which is that, sir, I think the next 2 quarters is when we will start seeing the effect of $30 billion of exports becoming nil. And that is really, really worrying, even with the rupee depreciation. And I think, therefore, the government and the RBI is thinking out of box. But I feel that eventually RBI will come up with some regime, but a very, very calibrated one, because they don't want to also permit indiscriminate lending. But this kind of economic scenario and the current scare is what will drive the RBI to come up with these creative models.
My first reading suggested that it's conservative way to start with. It applies to listed companies. It applies for companies with 3 years of consistent profitability. It also has restrictions that eventually after the transaction, the debt equity of 3:1 used to be maintained. So it's a slow start. I don't know, Seema, what you see as the future of this. Very reformative. Over a period of time, it will play out. But I just feel that we need to wait and see. I don't know if you're experiencing clients expressing optimism on this.
I would just, pivot to a little different issue here, adding to what he said. See, I see most of our clients are more concerned with the regulatory scenarios and the bondage that they have because of certain structures that we have. When it comes to, let's say, hospital, healthcare, when it comes to education, when it comes to higher education, some of the regulatory bindings that we have in the deal structures is basically holding us back. What are the 2 aspirational areas that we have in India today? One is healthcare, a good healthcare system, and the other is the education system. And both of these systems are marred by so much of regulatory regulations. When it comes to hospital, they're supposed to be under not-for-profit entities. When it comes to education, you not only have educational laws, you have charity laws in each of these jurisdictions. What happens is, in my own dealing as a healthcare or in the hospitality sector or in the education sector, and including space sector, what is happening is there are so many private equity investors wanting to invest, including certain banks and through ECB routes. They're wanting to invest in these three primary sectors, but the constraints is that you need to be, at least in the first two sectors, in not-for-profit charity structures, which is basically holding back billions and billions of dollars of higher education investments, hospital investments, and for the simple reason because you can't take profit dividend from these for not-for-profit charity institutions. So what is happening is that they are trying to now circumvent the regulations, bring in the equity into regulated structures for creating equity structures which are not completely above board. I think more than coming up with more policy, what they need to do is to allow certain sectors like telecommunication, hospitality, healthcare and education sector to be moved away from this ultra-regulatory regime that we have today.
Sure. Manendra, I don't know if you want to react to that, but I also had a follow-up question on valuations. We have now valuations under FEMA, Companies Act, income tax regulation, which obviously prescribe different standards and different methodologies for determination of what indeed is a fair market value. How often do you see these situations in a real deal scenario, and how challenging it is? And do you see that these inconsistencies will be addressed by the regulators in the future?
Well, Mukesh, to answer that question, how often? I think in almost all the deals that we do, we see this issue, especially in cross-border matters, where you have FEMA on one hand, then you have company law on the other hand. Let's say if you're talking about a SEBI situation or a listed entity situation, then you have then formula driven by, say, if you're raising primary capital, then you have ICDR coming into the picture. Or if you're, say, doing a control deal or an open offer deal, then the takeover code comes into the picture. At times, of course, there is a correlation which is done, for example, in an open offer deal where the, say, if you're doing it through a primary issuance, the FEMA will say that, look, it will be basis the SEBI laws, and then there is that convergence that happening. But in an unlisted scenario, it becomes extremely challenging. Also from a taxation perspective, where you have Rule 11 UA coming into the picture. So at times there is that inconsistency or difference in the numbers that keeps coming between the FMV that is there, basis the FEMA valuation or the company law valuation, and then the 11 UA valuation. Then the question comes, how do you bridge that gap, right? Then there are situations where you will end up you will have structures, say earn-out structures, or say indemnity provisions coming into the picture, or you will have deferred considerations coming into the picture. All of these then come into the picture, and then because there is no synergy as far as the valuation rules are concerned, it is a problem that we have seen across in almost all the deals that we do. The easiest way that we try and bridge this gap is try and see that there is a similar approach which can be followed across all the three valuation principles which are there. If that is not the case, then of course we go back to the drawing board and then figure out commercially how we can take care of the difference in the valuations, specifically say if Rule 11 UA valuation is far different than what a FEMA valuation is going to be. So it's something that we see day in and day out, and there is that requirement that I think the regulator should, specifically if you are targeting to have more and more foreign investment coming into the country, we should have that synergistic approach in terms of valuation across the different laws which are there.
Rule 11 UA is Income Tax Rules 1962 because income tax has its own set of regulations. Every word and every sentence again becomes a subject matter of interpretation. Manendra, thanks. You made a very interesting reference to deferred. Vaibhav, next question is for you. We have this regulation that not more than 25% of the consideration can be deferred, parked in an escrow arrangement, or indemnified by the seller for a maximum period of 18 months. This is a FEMA regulation. How challenging is this? And don't you think that this regulation has outlived its importance?
I wouldn't go as far as saying this has outlived its importance. I think this goes to the very root of the fact that India is not convertible on capital account. I find it kind of ironic on a very separate note, sir, and to everybody else in the audience, that we go all over the world, we make strong pitch to invest in India, but what do we tell the foreign investors? If you come into India, you cannot come at a price lower than the fair market value. And when you exit the company, you cannot exit at a price higher than the fair market value. And then you tell foreign investors, please invest in this country. I kind of find that ironic because ultimately investors will come where they see that opportunity. Clearly, India presents an opportunity, but the Reserve Bank of India still is in that play where they believe that capital controls need to be there. And in that backdrop, they have laid down this limitation that, whenever there is a transaction and there is a deferred consideration between a resident and non-resident, not more than 25% can be deferred. And that can also only be provided that 25% is above the fair market value. So for instance, if a fair market value of a company is 100 rupees and you're striking the deal at 150, only then you can keep that 25 in an escrow. If the FMV itself is 100 and your strike price of the transaction is 100, you cannot keep 25 aside. Now that, to my mind, of course, when you explain this to lawyers in other parts of the world, they're scratching their heads saying, how can you put such regulatory limitations on what should be purely driven through contracts and the freedom that parties have depending on the risk that are involved. Having said that, I think until RBI does not give up its play on capital controls, these kind of rules and limitations will continue. And the fact that the rupee continues to depreciate doesn't help us to build any case to relax any of these rules. So I feel that some of these rules will remain. They do impact deal making in the country. But having said so, I think in the overall macroeconomic play, I don't think we'll be able to wish away these rules anytime soon.
Thank you. Seema, you wanted to add something to that?
No, I think.
Correct. Let me come to the next question. 2025 deals, experiences of some of the deal lawyers that I spoke to, higher emphasis on indemnities, escrows, earnouts, deferred considerations. Do you think that the risk allocation in the Indian M&A space structurally has shifted in favor of the buyers, or is this merely an outcome of global uncertainty?
I think it's a combination of factors. One is the liquidity issue, whether the funding is being drying up. ECBs are hard to get. But indemnification and a deferred payment has always been part of the deal structures. What is happening is the aggressiveness with which it is being negotiated now. Earlier, if we were doing, let's say, 10 to 12 deals in a way, there would be 3 to 4 deals which will have deferred consideration or an escrow arrangement. But now, all the deals that we negotiate starts with the concept that any deal that we are doing will have 10% for sure a deferred consideration, which will be paid out as an earn-out. Earn-out, which basically means you will be getting that money, you earn that out over the next period of 1 year or 18 months. So that's something which is on the table to start with. Earlier, it was, let's say, in 20 to 25% cases. So there is an aggressiveness to that. Indemnification, there is a trend. What is happening is that more and more the impetus of the buyer is to indemnify against all possible scenarios. Earlier, the deals used to be that, secure some larger aspects of take some reps and warranties, secure some larger aspects of the deal. But right now, the way the reps and warranties schedules are possibly going into, starting from 7 to 8 pages, now it's going into 15, 20 pages, sometimes bigger than the document itself, the contract itself. This aversion to any kind of exposure, not that it diminishes any possibility of litigation, it does end up in being litigious and contentious going forward. But there is a trend to minimize the exposure, and I think that is happening because the funding, it is right now, 2025 has been a buyer's market. And therefore, they were able to have those kind of no risk, diminishing returns kind of scenario.
Vaibhav, you want to?
I actually have had a very different experience. I must share this with all of you. What we are seeing now is that if a deal value is more than 200, 300 crore Indian rupees, invariably there is a banker who's running he's running almost like a bid-like situation. And invariably, the sellers are turning around and saying, we will not give you business reps and warranties. Because these are bid-like situations, so there are many bidders trying to bid for the same asset. So they're coming in from a position of strength. Of course, there will be those exceptions where the seller is more desperate to get out. But our experience over the last 1 year has been that gone are those days where you're negotiating indemnities at length with the seller. The seller's starting position is, I'm not giving you business reps and warranties. And then as a buyer in a bid-like situation, I'm being forced to therefore consider insurance, rep and warranty insurance as a way to mitigate my risk. And the sellers are telling you, price in the premium in your bid. But I will not stand behind the reps and warranties. And one of the additional reasons why this is happening is that, earlier, sir, the owner of the company was largely the promoter himself. Today, if you look at any reasonably mature company, even if they are not publicly listed, even private companies, there is a large number of institutional financial investors, such as VC investors, such as private equity investors, who are owning large chunks of the company. So by the time a Series E or a Series F has happened, the promoter is down to 20-25%, if he's lucky, if he or she's lucky. The financial investors are sitting with 75% of the cap table. And the financial investor's position is, I will not give you business reps and warranties because I have not been running the day-to-day show. Of course, there are some exceptions where a large private equity owns more than 51%, but that's not happening as often. So the sellers and the financial investors are saying, we will not give business reps and warranties. The promoter is saying, I only own 25% in the company. So if I'm doing a $100 million deal, I can only give you reps and warranties around $25 million, which doesn't work for the buyer. So what we are seeing of late is we are spending incredible amount of time with insurance brokers, sitting down, trying to negotiate insurance policies around the indemnity cover. So that's an interesting trend. We've spent a lot of time now getting educated on that.
Manendra has a comment.
That's a fair point that Vaibhav has made. And I think it also depends from the sector to sector in which you are. And of course, the promoter, how much do they control at the end of the day. Insurance brokers are, in fact, becoming the hot topic as we speak. I think if not, say 90%, but at least say in 60 to 70% deals we are seeing the indemnity insurance is being negotiated, heavily negotiated, which actually is a win-win position for both the sides, be it for the buyer or for the seller. And that's where I think now the litigation funding is also going to be picking up majorly, right? Because where, say, even the banks or even the financial institutions are able to fund the litigation, which is going to be taking the promoters or the main guys off the hook. So also, I think that's something which is also going to be becoming, which is equivalent to something what we are seeing in the form of indemnity insurance. Also, the litigation funding is going to becoming the next big thing in the line of, say, dispute resolutions also.
Manendra, one follow-up question for you. Again, trend in 2025. Is it becoming more common in the M&A space, which is the post-closing disputes, particularly transactions that involved complex earn-out formulas, indemnities being worded in a very complex manner, and regulatory non-compliances, which got picked up at the due diligence stage. Is that your experience as well?
Well, I'll say it's been a mixed of such cases. Yes, I will not say it's completely gone. But more and more we are seeing parties trying to negotiate a settlement out of a dispute situation. That's something where we are seeing the trend going in that direction, rather than parties actually litigating it for years and years. Because, see, we had litigation to begin with as the first mode of resolving disputes. Then we brought in arbitration, right? Arbitration also has lived its life in terms of trying and resolving its disputes, right? Arbitrations now also run for 3, 4, 5 years, which is not acting as a speedy disposal of disputes, which is what it was intended to. What it is doing in the process is people are getting tired, parties are getting tired, they don't want to spend money over lawyers just to try and litigate over stuff. So parties are trying to take haircut and try and resolving disputes. I think that's where we are seeing a lot of trend happening, and which is where I think the third party intervening players, say the indemnity insurance guys or the litigation funding guys, these guys are now picking up more pace in terms of resolving these dispute situations.
I'm drawing inspiration from the earlier session on ESG. Do you, in your deal experience, see interplay of ESG considerations, particularly if there are very hardwired, clauses, or to be able to deal with allied legislations, or to ensure stricter adaptation becoming a real deal breaker?
Yeah, so ESG is no longer a must, should be there, but it is an essentiality. It's a necessity for any deal to happen. For instance, the attractiveness of the investee company to be able to track more bidders, the ability to have better valuation, the ability to get the deal actually to the closure is all based on the ESG compliances. So more and more what we are seeing in the last 3 to 4 years, that the ESG, when it comes from legal compliances, when it comes from financial ESG compliances, and reputational risk emanating from not compliance of the ESG, is becoming very important part of the deal making. So M&A means that the financial advisors and the legal advisors will do a thorough assessment, and now there is a third angle of the third party reputational risk associated to non-compliance with the ESG. So this is when the ESG, when the deal is being discussed, any entity which is ESG compliant is a potential entity which will have many more bidders and many more buyers, and the possibility of its closure is much, much more higher. So it's a real deal now.
Vaibhav, you wanted to add some? Just another futuristic question. What are the deal makers watching or anticipating in terms of market sentiment and regulation, keeping in mind that we are just about few weeks away from the budget of 2026? Do you see something as big bang as it was announced last year on banks being able to fund the M&A transactions?
That's a tough one. It takes a bit of crystal ball gazing. I think the government, as I mentioned, and I can't overemphasize the point that I think the government and the Reserve Bank recognize the fact that there is a bit of a crisis at the moment. With the coming 2 quarters, the realization of $30 billion becoming zero in terms of exports to the US will hurt us. And but what do difficult circumstances do? They give great opportunities to pivot. Some would argue that GST 2.0 was as a result of that difficult scenario that we find ourselves in. I do expect some consultations have started at an industry level. I do expect some industry-focused concessions to be made. Some rules around exchange control and leverage buyouts and things like those will become a lot easier. I also feel that particularly in the infrastructure sector, sir, there will be some greater dilutions on some of the restrictions around promoter contribution being financed. So those will be incremental changes that you will see. How out of box do they go is the key question. And I think somewhere where those trade negotiations lead us will drive the motivation of how creative they want to get.
You wanted to?
Yeah, I think for a very long time when the budget used to come, we as corporate lawyers also got very excited when, say, the changes in FEMA or even SEBI or even company law were introduced via budget, which is, I mean, in my honest opinion, it's not required. Like, you can do separate independent amendments to those laws, not necessarily routed through the budget. But I think gone are those days when the government is implementing these changes, at least in these corporate laws, through the budget route. But independent of the budget, I feel government is already focusing a lot on trying and see how they can make the whole investment market lucrative, not just for the foreign investors, but also try and bring a sense of stability within the domestic market also. I'll take an example of the securities market code, which is right now introduced in the Lok Sabha, right? I mean, it's a massive, massive move that the government has done, consolidating SCRA, SEBI, Depositories Act. Earlier, government securities were also supposed to form part of it, but it is not, as I see. But I think those regulatory reforms are already being done by the government in an independent capacity and delinking it from the budget perspective. So I think the government's focus is already there. Budget is going to be more on the point of view of trying and ensuring that expenses are given to the right areas which are going to be picking up where we can get more foreign investment. say the manufacturing sector or the electronics, or in fact say even AI driven sectors, right? So I think those are the areas where the government is going to be focusing and putting a lot of budget in those sectors.
Since I promised that I will end with the buzz, let me just give 1 minute to each of our panelists. I felt if 2025 was a year of resilience and recalibration, 2026 could be scaling sophistication and strategic dominance in the M&A space. Do you have any closing comments on what should be done to incentivize M&A practice in India?
I think the government has to deregulate and specifically focus on 3 critical areas. One is defense. The amount of budgets that we have for defense procurement and defense imports. We have held back for a very long time in defense manufacturing within India, and we have put ourselves as a government, we have put a lot of hurdles in that process. That needs to change because we have a licensing process. The second area that they really need to work hard is getting the space sector move very fast, which is happening at a tremendous speed, but we are a minuscule part of the entire ecosystem of the world ecosystem in terms of space and satellite campaign. That needs to change, and I think they need to change the archaic regulations related to education sector in India.
Yeah, I mean, first of all, just to add to the point that he was making, can't agree more. If you think about it, in the last 30 days, 3 big changes have happened. You have the new labor codes. You now have the data privacy rules and the data law coming into force with full fury. And the insurance law bill got passed yesterday where FDI has been increased to 100%. So clearly the government's not sitting idle. They're making a lot of changes, and with the securities law bill being pushed today. I feel that we will incrementally continue to grow in this space. I think what will be important is for the government to be responsive and receptive to feedback from practitioners. One very quick example where I'm very proud of what the government did was, I think, the realization that we need to do ghar vapsi of startups where holding structures were outside of India. Government quickly realized that you need to bring back the holding companies into India. They came up with a fast-track merger scheme. They allowed cross-border mergers. The RBI came up with an automatic regime. And you've started seeing NCLT's approved merger. I think Flipkart got its approval yesterday, which will pave way for the IPO. Meesho did that, and we supported them in that exercise as well. So I think the government being responsive and picking up where there's an opportunity, I think that has been something which has been a very welcome step. And I just hope that we continue in that direction. The government and the regulators get a lot of bricks from everybody, but I think where they've done something on their own and something which everybody appreciates, I think they deserve all the accolades as well. This is one example of that.
Certainly accelerated regulatory developments. Your take, in fact, we've already laid down the basis for acceleration in 2026, just with the month of December that we have seen, the 3 important changes, Vaibhav, you spoke about.
Yes, Mukesh, I think going forward, what government should focus on, while their focus is rightly there to ensure that we are able to increase M&A activity, deal activity, but in reality, when we are seeing how do deals get executed is, say, for example, through courts, right? We are seeing a logjam at NCLTs, right? We are seeing, I mean, if you are going for a tax-neutral merger, you are going to go through an NCLT route. Cases are pending for 9 months to begin with, right? So that just loses the entire charm of how a deal making should happen, and that's not something which is going to be incentivizing foreign players to come and do structuring or a tax-neutral mergers, acquisitions in India. I think that's where the government should really focus on. There are a lot of patients, but there are hardly any doctors. You go to an NCLT, the merger matters just take back seat, right? They're not. It's just not there. The alternate to that, which is a fast-track merger. Good part, government on paper expanded the scope of entities which can utilize that route. But I mean, from a practical perspective, having done fast track mergers, I'm telling you, I mean, that is also taking a lot of time. There are a lot of repetition in the process and the procedure that even at the RD level we are seeing. So I think those are 2 places where the government really needs to focus on how can they actually bring the law into play and effective enforcement of those laws. And that's something where the government should really, really focus on. And I think after that is just going to be some path breaking for the foreign players or even for the domestic players to move forward.
Terrific. On that note, please thank the panel for an excellent exposition.